Private international law is the remit of national legislation, and there's no convention on consumer protection and private international law. So usually national law will relate to either some public policy that will set the criteria, which is the point of connection to address the conflict of laws, or it will remit itself to general civil law. Now, we find this problematic because general civil law usually relates or reposes on the will of the parties. And although the contract between a business and a consumer may contain a selection of both jurisdiction and conflict of laws, it is not clear that consumers actually consent to this willingly. Usually consumers click and hope for the best. They don't read what the general contract terms are because they are 30 pages long. So, and just as much as consumer protection can counter some unfair terms and conditions, it may be arguable that a choice of law in general terms may not be opposable to a consumer. The idea behind some choices of public policy for private international law, putting the law of residence of the consumer or the jurisdiction of residence of the consumer, is that the consumer is the weaker party, and the consumer is probably more aware of the expectations that he or she may have in its national context. Some may argue that it is better to have the applicable law of the country where the business has received the acceptance of the contract, which sometimes it is in also a point of connection. So say if Indian, Indonesian, Thai consumer engages with a US business, some may argue that it is better to have the substantive law point of connection of US law because it may be more protective of consumer rights than their national legislation. I would counter to that is probably irrelevant if the consumer does not know it and cannot really action those rights. And we cannot expect consumers to know what is the best forum shopping or choice of laws when engaging in a consumer operation. So I think here there is room for improvement of clear public policy setting, which is a clear point of connection for all consumer contracts. I think a simple principle would be the country of residence of the consumer and the execution or place of residence of the consumer for both the connection of conflict of laws and jurisdiction. And that would also include the online dispute resolution institution that would be competent to solve the consumer dispute.